This is an appeal in the matter of NW High-Tech Contracts UK Limited and Outotec USA Incorporated and another.
Yes, good morning. The primary matter of logistics is it's quite warm in here. We may see how we go, but at the moment we think we might simply disrobe. We know that it's being live streamed, but we doubt whether the foundations of British justice will topple if we take our robes off. So we'll see how we go, but I don't want it to be a distraction, so I don't want it to be too warm. So that's that. Secondly, you'll take your own course. I'm sure you've probably talked about it, but at the moment, we think on the issue that remains, the Outotec appeal, we think with the following wind, it's capable of being dealt with today. But of course, we have tomorrow, so that it's not a listing difficulty, but just so that you know, that's what we think.
Yes. My Lord, first of all, I should deal with appearances. I appear for Outotec, the appellant, defendant below, with Mr. Berry and Mr. Steele. As you're aware, an issue has arisen as to the representation of MW. Mr. Temminck is unable to appear today, and they are represented today by Mr. Hale.
Yeah.
So, as regards the logistics, first of all, can I convey the gratitude of Council for the small mercy of being allowed to remove our wigs.
Yes, if you'd like to take your gowns off, you're very welcome.
I'll take advantage. It is going to get very hot. And for my part, I haven't discussed it with Mr. Hale in any detail, but we think for Outotec it's a day.
Yeah, fine. Okay. I'm going to take my robe off.
Excellent.
Much better.
By this appeal, Outotec contend that the judge was wrong to conclude that what I will refer to as MW's new claim did not fall to be struck out. Essentially, there were three reasons he came to that conclusion. One, that proceedings against the second defendant, Mezzo, would continue in any event under a parent company guarantee. I'll call that the PCG point. Secondly, that there were other proceedings between the same parties in relation to similar issues in relation to two other sites, Levenseat and Surrey, which I'll refer to as the other proceedings point. And thirdly, that although there had been a breach of the ALDI guidelines, which I'll come back to in a moment, that was not sufficient to amount to an abuse. We submit that MW's claim in fraud against Outotec could and should have been brought in the original proceedings between the parties in 2019. It therefore falls within the scope of the Henderson and Johnson principle and should have been struck out. We are being unjustly harassed by being required to engage with MW in further substantial litigation in respect of the whole plant. Now, I'm going to develop that submission in 8 parts. First of all, MW's previous claim. Secondly, MW's new claim. Thirdly, the relevant parts of the judgment. 4, the relevant authorities.
Hang on.
Sorry.
If these are the headings,
These are the headings.
that I then keep you to, I need to know what they are. So the relevant parts of the judgment, 4 relevant authorities.
Relevant authorities.
Yeah.
5, the test to be applied on this appeal.
Yeah.
6, the PCG point. 7, the other proceedings point. And 8, ALDI.
Yeah.
So turning to topic 1, the original proceedings, as your lordships would have seen, the original proceedings were started by a company called EWH against MW, who were the defendant. We were brought in as a Part 20 defendant. They related to the construction of a new waste-to-energy power plant in Hull. MW were the main contractor, we were a subcontractor, and there were parent company guarantees, which we'll look at in a bit more detail in a moment. To say the least, the project was not a great success. There were considerable delays, and in the event in March 2019, EWH terminated NW's employment. And owing to a provision in the main contract, MW were required to assign all the subcontracts, the benefits of the subcontracts to EWH, which they did. And that, as your Lordship may have seen, created some difficulties for MW in pursuing the Part 20 proceedings. In those original proceedings, these were very substantial claims. EWH were claiming, we'll look at this in a bit more detail in a moment, damages for delay, for termination and for defects, and that claim came to £168 million. EWH were quick out of the blocks, and they started the original proceedings very shortly after termination. So there were various procedural...
Well, that's not uncommon, is it? If you terminate a major contract, then you tend to want confirmation that you're right, given the potential downside if you're not.
Indeed, yes. There's no criticism of EWH for doing that. It's just relevant to the chronology. So we had a COVID-style trial in the summer of 2021 with counsel wearing masks, witnesses appearing remotely and so on. And that was a 5-week trial. There were then substantial written and oral closings during August and September of 2021. And in just before Christmas of 2022, the judge, Mr. Justice Pepperell, handed down a very substantial judgment, and then he then handed down a further judgment in May of 2023. May just be worth briefly looking at the main judgment. That's in your supplemental bundle at tab 5. So if we go to page 60, at paragraph 3, the judge summarised the main issues arising in the main proceedings. I told you about determination, and that was purportedly pursuant to a clause which we'll look at in a moment, and the judge identified the principal issue in the main proceedings was whether EWH were entitled to terminate the contract or whether M&W was entitled to an extension of time. And turning over to paragraph 6 on page 61, the judge reached some fairly trenchant conclusions. For example, at 6.2, M&W was not entitled to any extension of time. 6.3, EWH was entitled to and did terminate for default. And what flowed from all that was a very substantial award of damages of £117 million, liquidated damages and termination claims, and then a more modest recovery for defects over the page at 6.7 of £2 million. So the reason the judge was interested in extension of time was because if you go forward to page 72, clause 44.1c was the crucial clause. If they have...
sorry, 72.
72,
That's 72 in the paper version. Can I just ask a very simple question which doesn't require an answer? Is it technically possible to have electronic bundles where the numbering electronically matches the numbering on paper? Because so far, I think we're 2 pages out because of the index.
Yes.
Is it possible?
Well, I think the man or woman who resolves that conundrum
Is not you.
rich.
You're ducking.
Yeah.
But that's fine. I don't require an answer. It's just...
It is very frustrating.
That's a very good way of putting it.
Yes.
So if we,
Add two.
it was page 72, you're referring to paper.
I'm referring to paper. I should be
Fine.
referring to paper, I'm afraid.
Fine, okay. Right, so page 72, paragraph,
39.
oh yeah,
So effectively, once M&W, the contractor, have become liable for damages up to the cap which they had, then the purchaser can terminate the employment of the contractor with immediate effect. And the only answer to that, which we see over on the next page, both paper and electronic, is an extension of time claim, but unfortunately, the judge, but unfortunately for M&W, the judge roundly rejected that claim. So I think that's all we need to look at in that judgment. Now, December 2022 was a busy time in the course of those proceedings because, as your lordships will imagine, this rather hefty draft had been circulated, I think possibly in November of 2022, with a request for corrections and comment. And while that process was going on...
Yeah, if I've understood it correctly, the judge went a bit further than normally, because normally a draft is circulated for correction of typos and the like only.
Yes.
But he specifically, in this case, went a bit further than that and invited comment as to whether he'd overlooked anything.
Yes. Well, it was...
Have I got that right?
My lord, that's exactly right. And that was a not unreasonable request from the judge because, as you will have appreciated, there were many, many issues.
But the consequence of that was that the parties got it further ahead of hand than one might have normally expected.
That's right. That's right. Yes. But while all that was going on and corrections were coming in, EWH and MW were in the course of negotiations, and that bore fruit on the 16th of December, which I think from memory was the Friday before Christmas. And that's in the same supplemental bundle, tab 4, page 37, on paper.
Page 39.
Page 39, electronic.
Thank you.
And one sees there, clause 3.1, in full and final settlement, M&W and the parent have agreed to pay to EWH £75 million. And we'll see that figure again in a moment. Now, I mentioned that there were Part 20 proceedings in the original proceedings, and we find the pleading of those at tab 2, starting on page 7, paper, page 9, electronic. And there were a number of claims which were sought to be made in the original version on the basis that the subcontract still persisted as between M&W and Outotec. So there was a claim for delay damages.
I beg your pardon, could you give me the reference again?
Yes, it's tab 2 in the supplemental bundle, and it begins on page 7, paper, page 9, electronic.
Thank you.
So the first main claim was at page 10 paper, page 12 electronic, which complained of delay on the part of Outotec in delivering plant and equipment, which was said at page 12 on paper, page 14 electronic, to give rise to a liability for liquidated damages of about $5 million. Secondly, there was a claim for defects which were essentially being passed down. Some of the defects claimed by EWH were sought to be passed down by M&W to Outotec, 15 in all. And paragraph 23 on page 12 is worth noting, page 12 paper. For the avoidance of doubt, this includes not only any direct remedial costs associated with the defect, but also any other liability which M&W would not have incurred but for the defect. Where the defect impacted on the critical part of the completion of the works, that's the main works, this will include M&W's increased liability for liquidated damages as a result of the defect, and also for any impact on MW's liability regarding termination. Then turning over the page, we see that at this stage this is put both on a contractual basis. It was contended that paragraph 26, the assignment which I referred to earlier, had only transferred to EWH the right to the benefit of future performance and did not transfer any accrued rights, and so the claim is brought primarily on that basis. Alternatively, it's a claim for contribution under the 78 Act, for delay, that's delay to the main works, loss flowing from termination, that's termination of main works, and the cost of remedying the defects. Now, this particular judgment isn't in the bundle, but there was a preliminary issue taken before Mrs. Justice O'Farrell as to that assignment point, and she concluded that the assignment precluded the contractual claim, so that it had assigned both future and past rights under the subcontract, and she also held that there were limitations on the contribution claim that could be made. So by the time we got to the trial in the summer of 2021, the principal issues pursued by M&W against Outotec related to the 15 defects which were sought to be passed on. The judge, Mrs. Justice O'Farrell, had said that in principle there could be a contribution claim in relation to same damage in respect or delay, but that was undermined by agreed expert delay evidence, and M&W abandoned that case shortly before the trial. There were also counterclaims in the Part 20 proceedings by Outotec for unpaid milestone payments and other matters. The upshot of the two judgments of Mr. Justice Pepperell was that Outotec was entitled to about £9 million principal, about £2 million interest and costs. And the key
Can I just ask on that?
Yes.
I've had a look at the second judgment, albeit not in huge detail, which is principally concerned with the defects, as I understand it.
Yeah.
And is this right? The reason that Outotec were successful was that effectively was because of their counterclaim, because they had a cross claim for monies owing.
Yes, that was why there was a net sum due to Outotec.
That's why there was a net sum due. And do I see that identified in the second judgment? I know those are the figures, and I know there's no debate about it. I just wonder what the mechanics were as to where the 9 million got identified.
Those were resolved in the first judgment.
Right.
If you could go to supplemental bundle tab 5, paper 269, electronic 271.
Yes.
So that's para 806, that's a summary of what the judge had concluded on milestones.
And then OTEC's counterclaim the defence of abatement.
Yep.
So fine. And so that was where that came in. And so the is this right? The second judgment was limited to the defects and MW's defence of abatement.
Yes, it was essentially, yes.
Yeah. Fine.
So just to make that good, just to summarise what was found in each judgment, if Lordships could go back to paper 63, electronic 65, still in the supplemental bundle. So at para 7, the judge provides a useful summary of the Part 20 decisions. The first one is just worth noting in passing. That was going to be the subject of the other appeal, the M&W appeal. This is the clause 37 point, but that's gone away.
Yeah.
The judge dismissed contribution claims in respect of certain defects entirely. In relation to what we call defect 17, they got a partial success, which was then assessed in due course in the second judgment. And then there's the counterclaim I will ask me about the defence of abatement, which the judge dealt with in principle. And there's also a point about liquidated damages, which I don't think we need to get into. And then in the second judgment, that's tab 6, page 286, paper 288 electronic.
Two eight.
286, paper 288 electronic.
Yeah.
So the judge dealt with some of the more minor defects and some of the outstanding issues on the more major defects. And the contribution claim came to a grand total of £20,000, which we see at 2.2. And then over at 2.4, the defence of abatement succeeded in about $500,000 US.
Yeah.
So that's a slightly whistle-stop tour of the original proceedings, but I think that's sufficient for present purposes. So turning then to item 2 on my list, which is the new proceedings. As I mentioned earlier, December 2022 was a busy period, and M&W issued the present proceedings on the 21st of December, just after the Part 1 judgment and just after the settlement of the dispute with EWH. And this is, on any view, a massive fraud claim. It should be noted again in, I think, in passing, that M&W sought once more to get a contractual claim on its feet. As part of the settlement, the subcontract with Outotec had been assigned back, reassigned to M&W, and M&W then sought to argue that they were thus entitled to make contractual claims against Outotec. However, the judge struck out that claim, and my Lord Justice Coulson refused permission for that issue to be raised on appeal. So that is that. So turning to what is in the new proceedings, if your Lordships could go to core bundle, volume 1, paper, tab 7.
Just to make life interesting, I'm dealing with core bundle on paper.
My Lord, that will avoid the tedium for all concerned.
Yeah, it's just the supplementary bundle I'm using.
Yeah. So it's tab 7 at page 81. There's the claim form, and then just to get our bearings in terms of time, if you could go to page 87. The crucial date, it appears, for this claim is the 20th of November 2015, which is when the main contract and subcontract were entered into for Hull. Para 6 summarises Outotec's obligations, and then, relatively uncontentiously, paragraph 7 is somewhat more contentious.
Just on the context point and the timetable, and I should have made a note of it, and I haven't. What was the date of the main contract? That's the subcontract.
It's the same date.
Same date, 20th of November 2015. Thank you very much.
And they were effectively back to back.
Back to back, that's what it says here.
Yep.
So what they say is that there were fraudulent representations as to M&W's experience of this sort of kit, that M&W relied upon those representations. Those representations were false, and then at page 89, para 7.5, as a result, M&W sustained losses, which we'll look at in a bit more detail in a moment. Then if I could take you to...
And there's an alternative claim in negligent misrepresentation.
That's right.
Although that doesn't seem to feature much in the argument.
No.
Okay.
So in terms of the representations, if you could go to page 91, para 16. M&W say that there were 5 categories of representation which they have labelled E to E. Those were not contemporaneous labels on any view. And these are effectively, we would submit, M&W's summary of what they say they were told. And then at considerable length they develop in the main body of the pleading and in Schedule 1, which we'll look at a bit later, the basis for those alleged category representations. It is said that those representations induced M&W to enter into the contract, that they were false, and that they were made fraudulent. It should be noted, if you wish to go to page 116, para 58, that M&W rely on the defects, which are then pleaded below, which collectively and or separately demonstrate that Outotec did not have either plant or technology at the time the representations were made, or at any other time prior to entry into the subcontract. So the defects, although they're out for the purposes of a contractual claim, are still in for the purposes of a misrepresentation claim, because they are said to be further evidence of the falsity of the representations which were made. Now, if we could then see what the claim is, if you could go to page 135. So, unsurprisingly, in a misrepresentation claim, their principal case is that but for the misrepresentations, they would not have entered into either the main contract or the subcontract. And so they say, if they hadn't done that, they wouldn't have suffered the loss which they then set out. And the total, which one sees on page 136, is £167 million. And if you then go halfway up the page, you'll see that the largest single item is the settlement sum to EWH of £75 million. Then the first 3 items on page 135 and the next 8 or so items on page 136 are essentially all the costs which they incurred in performing the main contract. Works. They also claim back the Outotec counterclaim, which we saw a moment ago. They claim back all the costs which they had to pay in the main and Part 20 proceedings, and they claim back what are called business closure costs. Credit is then given for various monies which have been received, and that then gives you the total sum claimed of £166 million. And those claims, which we'll perhaps look at in a bit more detail, are also claimed under the PCG. So that's where the new proceedings are. The situation in relation to those is that pleadings have been exchanged. There is a CMC due to be heard at the end of July, and the trial is fixed for February 2026. We've not yet had directions for witness statements and the like. So, my lords, those are the new proceedings. I was going to turn thirdly to the judgment, and that is at tab 5 in the same bundle. So the first relevant question which the judge considered, beginning on page 68, was whether, para 108, whether MW could have ruled the misrepresentation claim in the previous proceedings, and he then rehearsed the various evidence and submissions which he had heard, and we'll come back to some of those points in a moment. But his conclusion, para 118, is this: in summary, page 71, therefore I consider that the answer to the could question is yes. In this, in my judgment, MW could, had it decided that it wanted to do so, have investigated and pleaded the misrepresentation claim in reasonable detail by late 2019. If I'm wrong about that, it needed some more time, and it could and should have agreed to EWH's suggestion to extend the performance bond to buy itself that further time. But that's a reference, as I mentioned earlier, EWH were quick out of the traps with their claim, but they did make an offer to MW, so well, you can have some more time to sort out your defence and any other claims you want to make, but they'll have to agree an extension of the performance bond, and they didn't snap that up. So then the judge deals with the should question. Again, perhaps come back to some of those points in more detail, but his conclusion, para 130 on page 73, is that there was a failure to comply with the ALDI guidelines, which is a factor which weighs against it, especially because had it acted with appropriate expedition from the outset, the misrepresentation claim could, should, and probably would have been tried with the previous proceedings. Now just pausing there, and there are some other helpful findings elsewhere in the judgment. It should be noted that M&W have not sought to serve a respondent's notice to challenge any of the adverse findings which the judge made, and our submission they are therefore stuck with them.
Is it your submission that where he says probably would, that's a binary balance of probabilities, that is what would have happened? Or do you say it means something different?
I'm not sure what else it could mean.
Well, in the context, one view could be, in the context of the 20 paragraphs or so beforehand, is that the judge recognises that there are a number of prospective outcomes as to which he cannot be certain which one would be followed. So although his view is that it's the most likely outcome is, he's not making a finding of fact as you would in a different context, that on the balance of probability that would happen. That's at the moment how I read what he's saying. It's more nuanced than simply a binary finding.
Well, he's clearly, in the light of the discussion earlier in the judgment, he's clearly not in a position to be certain about any.
No, but not certain on the balance of probability. The distinction that I'm going to press you on is the distinction between a binary finding that this probably would have happened, like a normal binary finding of fact, where applying the balance of probabilities, and a more nuanced conclusion, which is that although he thinks that is the most likely, he cannot exclude the others, and that's the working, as it were, the dough with which you work.
Yes. Well, this may be a convenient point to make this point, but the next sentence where the judge refers
Well,
to...
before you get into the next sentence, I appreciate why you're going to draw attention to that, but can we factor into the debate another question? At the moment, it seems to me the judge is doing two things here, and I invite your comment. Firstly, he's answering a question about the claim and whether it should have been brought as part of the previous proceedings. That's the could question and the should question. He then goes on to consider, it appears to me at the moment, a third question, which is if the new claim had been brought as part of the previous proceedings, as he says it should have been, what would have happened to it in terms of trial? Now, do you say that's a correct way of analysing the judgment or not?
Yes, and in my submission, although it's an interesting discussion upon which the judge embarks, in my submission we don't need to go that far, because if the court concludes that the fraud claim, misrepresentation claim, could and should have formed part of the original proceedings, that in my submission is good enough. Now, whether it would all have been tried together is another matter.
It's good enough for you for what? To compel a finding that there's oppressive abuse?
To compel it's very close in my submission to requiring a finding.
Well, you need to be a bit precise, because when you say it's good enough and turn happily on to the next point, good enough for what?
That is necessarily an abuse of process.
Okay.
That's
your case.
well, we'll look at the authorities in a moment. That's a nice mission where the authorities take us. But my Lord Justice Arnold is, with respect, correct to say that the judge here is debating with himself exactly how, if the fraud claim had been brought with the original proceedings, it might have been tried, which is a somewhat different issue. Because we'll get to the authorities in a moment, but what the authorities emphasise is the need for candour between party and court. And in that process of candour, the party puts its cards on the table, and the court may say, well, those cards are going to go into the reserve stack, as it were. So the court might have said, well, the judge took a different view, but the court might have said, this is a pretty big claim anyway. We'll put certain issues over to another trial. But that's
and you say bifurcating the trial doesn't affect the analysis.
No. So, well, just coming back to the points upon which, so the judge, having reached those conclusions, was against us for essentially three reasons. One, the PCG point, which we see summarised at para 136 on page 75. Since the claim against Nexo will continue in any event, it is difficult to justify the striking out the claim against the subsidiary. So that's the PCG point. Secondly, also in that paragraph, is the fact that there are these other proceedings. And then thirdly, although there is a breach of the ALDI guidelines, and this we get at para 134 on the previous page, it is not the most egregious of non-compliances. And we say the judge was wrong on those points, which I'll develop that solution in a moment. So, my lords, turning then to the authorities, and I think a convenient starting point, in fact, is our skeleton. We can put away call bundle 1 for the time being, get out call bundle 2, tab 10.
Sorry, where are you? Your skeleton, tab 2 of the core bundle.
It's volume 2 of the call bundle, tab 10, page 475.
Thank you.
So really, the law in this area, the present for all purposes, begins with Lord Bingham's speech in the Gore Wood case, in relation to my Lord Justice Stuart-Smith's question a moment ago, I would emphasise the first sentence of what we've set out at paragraph 24. It's wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to render the raising this in later proceedings necessarily abusive. And Lord Justice Clark, as he then was, summarises that point in his principle 4 in the next paragraph. It is wrong to hold that because a matter could have been raised in earlier proceedings, it should have been, so as to render the raising of it in later proceedings necessarily abusive. And our submission is that if the could question and the should question are both answered in favour of the applicant, we are either in the territory of necessarily abusive, or we're certainly very close to it.
And as I understand it, you say that the test is what's in the claim form, not how it would have been case managed and whether it would have been one trial or two. Should it have been in the earlier claim form?
Yes, that's the question, yes.
You are very close to a necessary finding, is that how you put it?
Yes. Well, that's the only way of making sense in my submission of Lord Bingham and Lord Justice Clark. I mean,
it's much easier to express the negative. If they're not both answered in your favour, it is very unlikely that you will get a finding of abusive conduct. And if you don't get a finding of abusive or oppressive conduct, you're not going to get a strikeout.
My lord, that's right. But in my submission, this is expressed as a negative, but to make sense of the negative, there must be a positive, and the positive must be subject to the fact that it is always a broad, merits-based judgment. The positive must always be that if the matter could and should have been raised in earlier proceedings, that is necessarily abusive or very close thereto.
It may not matter because it may be semantics, but it may not be, and some of the points so far at any rate might be semantic. None of this is dealing with brought. It's not claims brought, it's raised. So you raise before the court the claims. So that could mean raising with the court, look, we've got these vast claims. We haven't pleaded them out, but this is the subject matter.
Yes.
Because the judge refers to brought, which to my eye presupposes pleaded out. Whereas I'm not sure that that's what Lord Bingham and Lord Clark are talking about.
No, and my lord, even if they were, in our submission, Aldi has transformed the landscape here, and Aldi and the cases that follow it, in my submission, mean that if you have ongoing proceedings between A and B, but A knows or even has reasons to suspect they've got a big claim here, which is on the claim form, they've got another big claim in their locker here, then at the very least they have to refer that matter to the court,
Yeah.
to the defendant and to the court.
So that's the bottom line principle,
Yeah.
that instead of one party taking a unilateral decision, it is raised with the court, so it becomes a matter for the court to deal with.
Yes, exactly. Yes. So my lord, the submissions that we make on the law are the first I've effectively just made. Just to summarise it, where A and B are engaged in proceedings, but party A, the claimant, or here part 20 claimant, knows that it has another claim up its sleeve, it must at the very least notify the prospective defendant and the court of that fact. So that's our first submission. Secondly, that is our fortiori true, where the card up the sleeve relates to fraud. And thirdly, the point I've just made in answer to my Lord Justice Stuart-Smith's question is where a claim should and could and should have been raised in earlier proceedings, raising it in later proceedings is necessarily abusive, or at least almost inevitably abusive. So then, turning, if I may, to the authorities, we can put away the call bundle and your lordships. I have a bundle of authorities.
Just before you go,
Yeah.
just before you go, your last submission, where the party could, where the issue could and should have been raised in the context of original proceedings, you're at or very close to a necessary finding of abusive conduct, and there in that submission, you're taking on board my Lord Justice Coulson's point that raising doesn't necessarily mean pleading. It simply means notifying of the existence of, so that other people can take steps if they wish to, including the court.
Yes, but including, but in particular.
Yeah. Okay. Thank you.
So my lords, in the authorities bundle, I'll take this relatively quick. I imagine lordships are not unfamiliar with these cases, and I know at least one of them, one of my lords was involved in. But just to pick up a couple of points from Aldi. So the facts were that there had been essentially a claim A against B, and B had brought in WSP as a third party. Those proceedings were resolved, and Aldi then sought to bring new claims against WSP and were allowed to do so. But just on my Lord Justice Stuart-Smith's point and my Lord Justice Coulson's, it's worth just noting this is page 763 in the report. At para 21, WSP were made aware by Aldi that Aldi had a claim against them and it might be pursued. If WSP and Appellant were concerned that the prospect of a second action might cause that pressure, they could have responded to that correspondence in terms, putting Aldi on notice of their position and applying to the court if necessary. So there had been notification there to the prospective defendant, albeit not to the court. And then we emphasise 2 pages on the guidance which Lord Justice Thomas gave, and in particular paragraph 31. For the future, if a similar issue arises in complex commercial multi-party litigation, it must be referred to the court seized to the proceedings. It is plainly not only in the interest of the parties, but also in the public interests and in the interest of the efficient use of court resources that this is done. There can be no excuse for failure to do so in the future. So, my lords, that is very strong language, and that was agreed to by the remainder of the court, and that's why we submit that the landscape has been transformed in that regard. And then, so far as sleeves and cards are concerned, the decision of the Court of Appeal in Stewart and Goldberg-Lindy, which is the next tab, we submit is quite helpful. At 844, para 77, in Lord Justice Sedley's short judgment, there is a pithy restatement of the Aldi principle, and then this: a claimant who keeps a second claim against the secondment up his sleeve while prosecuting the first is at high risk of being held to abuse the court's process. Moreover, putting his cards on the table does not simply mean warning the defendant that another action is or may be in the pipeline. It means making it possible for the court to manage the issue so as to keep our state silent. And that except my Lord Justice Coulson's point. And in Lord Justice Clark's, Sir Anthony Clark, after the Rolls judgment, he emphasises at page 850, paragraph 96 and 97, beneath the card on the table.
And he says it's not justified because the second claim might involve other issues.
No, exactly. And we would submit the Court of Appeal are even more animated on this point in Gladman, which is the next chapter. And this was an appeal from my Lord Justice Arnold,
As I then wasn't.
I'm not quite sure what the correct reference is. An appeal from the then Mr. Justice Arnold. But what we pick out of that on page 266.
266.
266, para 65. This is Lord Justice Briggs as he then was. The conduct of civil proceedings is a process in which, para 65, in which the stakeholders include not merely the parties, but also other litigants waiting for the cases to be tried and the public at large. I consider that Mr. Justice Arnold was correct to treat a failure by the appellant to follow guidelines laid down as mandatory features of conduct in two successive reported decisions, and he's referring there to Aldi and Goldberg-Lindy as an abuse. He uses the term in the middle of the next paragraph, again, mandatory guidelines. The failure was inexcusable, an inexcusable failure to do something which would have contributed so substantially to the economy and efficiency with which this dispute might have been resolved seems to me to be a primary candidate for identification as an abuse. So, my Lord, came back to my Lord Justice Stuart-Smith's question a few moments ago. In terms of the third limb, what would have happened? In my submission, that is a much less hard-edged question.
Yeah. Your high point so far, because I'm trying to note the high point of your submissions, is high risk, Lord Justice Sedley, and relevant matters pointing to a conclusion in this judgment we're looking at. That's where we've got to so far.
Yes, and mandatory guidelines.
Yes,
Yeah.
But failure to comply with mandatory guidelines has this consequence.
Yeah.
Accept that.
Now, my Lord, the second submission we make is that where one is dealing with a fraud claim, the Aldi guidelines, Aldi of course was not a fraud claim, the Aldi guidelines apply with particular force. And in the Playboy case, which is at tab 6, this was a case where there were negligence proceedings, and it emerged during the course of those proceedings that there might be a claim also for fraud. And what Lord Justice says, as he then was, essentially said was, well, they didn't have sufficient information at the time of the original proceedings to take a view as to a fraud claim, and therefore they are acted reasonably in not pursuing it. But I would note what my Lord Justice Sales, says in paragraph 51, although this doesn't have imagination. So, having analysed the evidence in some detail. Para 51 will say this. In assessing whether it's an abusive process for the club to institute and maintain its deceit claim after the trial of the negligence claim, I consider it is important that the new evidence came into the club's hands after the material time, i.e. after the commencement of that trial. And then this is not a case in which a party has deliberately decided for tactical reasons to keep material up its sleeve in relation to a deceit claim till after it sees what happens with its negligence claim and then institutes later proceedings in deceit relying on material already available to us at an earlier stage. To proceed in that way might well be an abusive process, and refers to the various cases we've looked at. But in this case, the fair inference that the club has proceeded to bring the deceit claim by reason of new evidence becoming available, which is highly material and strongly supportive of that claim. So on the tour of the authorities, very briefly, Goldman, which is at tab 8, which is curiously enough a decision of His Honour Judge Stephen Davies, the judge in the present case. I don't think we need to traverse it in detail, but essentially what happened was that there was a trial. In the course of that trial, leading counsel was pursuing a witness. In the course of that cross-examination, material emerged to the surprise of leading counsel, which appeared to suggest there might be a fraud claim which had not been pursued up to that point. The judge concluded that they could not reasonably have been aware of that fraud claim at the earlier stage, so the should issue did not arise, so that he dealt with it over term. But well, again, just to pick out one point from that case, at page 258, left-hand column, Para 76. Nonetheless, there are, in my judgment, very significant points in favour of the claimant. This is not a case of the claimant who was aware of the alternative claim but consciously decided to hold it back. That is a very significant consideration, especially in a fraud claim. So well, that's my whirlwind tour of the authorities. And then finally on the law, on the could and should point, I've made the submission already, but just to emphasise it, it's apparent we would submit from Johnson, Dexter, and all those other cases that where a party could and should have raised a claim in earlier proceedings, raising the claim in later proceedings is necessarily abusive, or at least puts a party at very high risk of having the new claim struck out. That is why the cases we have looked at go into such detail as to what could and could not have been raised in earlier proceedings. In our submission, it is very rare for a court to conclude that where a claim could have been raised in earlier proceedings and should have been raised in earlier proceedings, nonetheless, there is not a finding of abuse. So,
well, this may not be a question for you, but is there any case in which a court has found that the new claim could and should have been brought in the earlier proceedings, but nevertheless there was no abuse? Is this the first one?
This will be the first one, I think. Yes. So, my lords, having asked you to, having said we finished with the authorities, I was going to deal briefly with the test to be applied on this appeal. And this is not controversial, but just to remind you, in Aldi tab 2 paragraph 16, this sort of decision, Lord Justice Thomas says there can be only one correct answer. However, I'm sorry.
So it's not an exercise of discretion.
No.
Sorry, can you remind me of the paragraph?
Yes, it's para 16, page 762. And noting, in fact, that the Court of Appeal were, in fact, reversing the decision of the very experienced GCC judge here. But so it's not a discretion, there's only one correct answer. However, it is sufficient for the purposes of this appeal to state
Yeah,
that.
well, that's been the subject of discussion in subsequent cases, because it's a conundrum, isn't it? I mean, if there's only one correct answer, then the Court of Appeal should give it, even if the first instance judge gave a different answer. If it's an evaluative assessment, that necessarily supposes that there can be more than one correct answer. So in your submission, what's the right approach?
Well, it's sufficient for my purposes to show in my submission that the judge has taken into account immaterial factors or omitted to take account immaterial factors or urging principle or come to an impermissible conclusion.
What's the answer if he's taken relevant matters into conclusion, but you would say he's given inappropriate weight?
Well, that would fall within the last words of erring in principle or country.
You'd have to say a decision that no judge directing themselves properly could have arrived at.
Well,
Yes?
it's an impermissible or not open decision.
Yeah. Impermissible is elastic. I want to be clear, your submission is that well, I've just slightly lost my train of thought. Can I ask you something which I wanted to ask you anyway? You haven't mentioned the word oppression yet, although it's laced through the authorities. Can you help me with this? Is the presence or absence of oppression relevant to the question of abuse, or only to the subsequent question, if there is abuse, whether to strike out? And if it's the latter, isn't that an exercise of discretion?
Well, we're taking that in stages. The authorities seem to suggest that, and there is, I think, as my Lord Justice Arnold may have been hinting, a degree of tension here. The authorities seem to suggest that there can only be one right answer as to the question of abuse of process. But if the court concludes there is an abuse of process, it doesn't then automatically strike out.
Is the presence of oppression or absence of oppression relevant to the question of abuse?
It's, in my submission, relevant but not necessary. So if the proceedings are, the new proceedings are oppressive, then a court
Definitely relevant.
Court's highly likely to conclude that they're abusive.
Fine. And if the proceedings are not oppressive,
Then
where does that fit in?
But there is nonetheless an abuse of process on this.
No. I think I'm going to rephrase your response just so that we don't misunderstand each other. If there is a failure to comply with the ALDI guidelines about notification in the earlier proceedings, is the question of whether or not the consequences are oppressive relevant to the question of abuse, or only to the question whether to strike out in the presence of abuse?
Well, I'm going to
Rephrase mine.
No, I'm going to try and stick to my guns and say that if there's oppression, that's clearly relevant to the question of whether there's an abuse.
Thank you.
But but if you've got a breach of the ALDI guidelines, then that is highly likely to constitute an abuse.
Irrespective of the question of oppression.
Irrespective of the question of oppression.
Okay.
But presence or absence of oppression would not be irrelevant to the exercise of discretion at the last stage in the analysis. But can I just summarise how we say we come within the words which begin, the judge has taken into account in the passage I've just shown you. We submit that the judge took into account or gave too much weight to immaterial factors, namely the claim under the PCG and the other proceedings. And so far as ALDI is concerned, we further submit that the judge omitted to take account of material factors, erred in principle, or came to an impermissible conclusion.
Sorry, just so that I'm clear. So the first thing, taking into account giving too much weight to irrelevant matters, i.e. the PCG and the other proceedings. And then, so that's that point. And in respect of ALDI, you say? That omitted to take account of material factors, erred in principle, or came to an impermissible conclusion in his assessment of the breach of the ALDI guidelines in circumstances where MW accept and aver that they took what they describe as a commercial decision not to raise the fraud issue in the original proceedings.
Before you go on, I'm sorry to go back to what you were discussing with my Lord Justice Stuart-Smith, but I was just looking back because in Johnson and Gore Wood, the expression used by Lord Bingham is unjust harassment. He may use the word oppression, but I can't find it, whereas I can see that he clearly says unjust harassment. He says there will rarely be a finding of abuse unless the later proceeding amounts to what the court regards as unjust harassment of a party. So he's not dogmatic even about that. The person who introduces the word abuse appears to be Lord Justice Clarke in Dexter, and he says the court will rarely find that later action is abuse of process unless the later action involves unjust harassment, Lord Bingham's term, or oppression. And that could be suggested to be an alternative.
Well, my Lord, just taking that in stages, clearly a party is entitled justly to harass another party if they have done them wrong. So, so that's presumably the distinction between just and unjust harassment. But the borderline between a case of unjust harassment and oppression, in my submission, is a very thin one, if it exists at all.
So your appeal, your primary appeal, or primary basis of appeal, is that whether or not there was unjust harassment or oppressive conduct in this case, the judge it was impermissible for the judge not to find that there was an abuse, and thereafter not to find that the case should be struck out. That's your primary.
That's how we put it on ALDI, yes.
Yeah.
But on the other 2 points, we submit their irrelevant factors for reasons I'll develop in a moment.
Mr. Williamson, can I just ask you that the last point you made before my Lord's plural questions?
Yeah.
There's a reference, you referred to them taking a commercial decision not to raise it.
Yeah.
And there's a reference to that in your skeleton, I think.
Yeah.
And that itself is a reference to a skeleton below, was it?
Well,
Do we have that?
You do, and we are going to go to it, if I may.
Okay,
But
fine.
in fact, MW have, if I may put it this way, doubled down on that submission, because it's not only in their skeleton below, but it's also in their skeleton before you.
Right. Well, just for my note, the references would be good.
If you wish, it will just give me a moment. So, in relation to the appeal skeleton, it is at core volume 2, tab 11, page 505. And in relation to the skeleton below,
505.
you might also want to go to that.
No, I'm just.
Well,
Oh yes.
And in relation,
sorry, which paragraph?
it's paragraph 47.1.
Yes.
And so far as the skeleton below, it is paragraph 27A, which is at supplemental bundle 7, page 322.
Very much.
SB what?
SB 7, page 322. So my lord probably has that as page 324.
Thank you.
My lords, I was just completing item 5 on my list, which is the test for you, and I just wanted to make this further point. In my submission, the central question for you is whether M&W abused the processes of the court by not raising their fraud claim in 2019, and that question must be judged as at 2019. And so the fact that there were PCG proceedings taken in 2022, and the fact that they started Surrey proceedings also in 2022, those two facts are in my submission either irrelevant or of very limited relevance. So coming then, so this is item 6 on my agenda, the PCG point. As we've seen, the judge took the view that because the claim against Mezzo, the guarantor, would continue.
Sorry, I'm sorry to interrupt you again. You said judge the position as of 2019. I'm just trying to understand that. So the date of the original claim form was whenever it was in 2019.
Yeah.
Sorry, can you remind me what that date was in 2019?
It is 27th of September. That's tab 2 of your supplemental one.
Right. But why does one assess point there? Because is it not clear from the case law that if a party to the original proceedings after the date of the claim form, but before trial, and let us assume insufficient time before trial, is in a position to formulate a new claim, then the principles articulated in Aldi rules apply. And Gladman is a case in point, because that was exactly what happened there. The claim in question, that was the subject matter of the second claim, had been explicitly formulated by the claimant, but it was not as at the date of the claim form in the first proceedings. It was between then and trial, and it was found insufficient time before trial to have pleaded it out. So why is the relevant date the date of the claim form in the first proceeding?
Well, if, as the judge found, it was M&W could have raised the fraud claim, I'm using that as a shorthand, in 2019. The fact that other things happened in 2022 extraneous to that claim is, in my submission, irrelevant.
But they're two different questions, aren't they? One is relevance of what you characterise as extraneous matters. And if they're extraneous whatever the date. Then there's a separate question, which is, as at what date do you have to decide whether the second claim should have been raised, to use the neutral word? And why is that the date of the first claim for? Why can't it be later?
Well, it could probably be later if there was some good and sufficient reason why it should be raised at that later stage, such as the acquisition of new material, as was canvassed in various other cases.
So, in fact, would you accept this proposition that the key date is the date sufficiently advanced of the first trial when the claim should have been raised, could and should have been raised, so as not to imperil the first trial date?
Yes.
Is that set in stone? I mean, if obviously the maintenance of a trial date is of extraordinary importance, and rightly given extraordinary importance by any judge managing a substantial piece of litigation. But until you get to a stage where the trial date is absolutely immutable, its time, for the purposes of my Lord's question, continues to run. And the mere fact you've got a trial date, say you had a trial date 2 years hence, listed for June, 2 years hence, and the consequence was putting it back to October. Highly undesirable, a judge wouldn't do it lightly, but possible. Does that affect your response to my Lord? I don't know the answer to that question. I don't know what I think the answer to that question is.
I think I'm at the moment, I'm in the same agnostic edition.
In that case, it's probably a duff question.
No, it's a duff answer, I'm afraid, but I will ponder it and come back to it if I may. Okay, can I just seek to develop the main point on the PCG, which is my item 6. In our submission, the PCG claim is simply irrelevant because the two defendants are two different legal persons, and the fact that a claim might continue against person B doesn't really have anything to say about whether a claim against person A is or is not an abuse of process. And one can test that proposition in this way. If the guarantee had been provided not by a related company, but by a bank, why would the possibility that proceedings might continue against the bank be relevant to the question of the guaranteed party being able to strike out proceedings against it as abusive? And furthermore, these two defendants are not, as it were, joined at the hip. The chronology is thus: there was a PCG, I don't mean to turn it up, but a first PCG was given in June 2017 by a company called Outotec OYJ, who were based in Finland. That company was then bought by Metso and became Metso Outotec OYJ, and the further PCGs of 2021 and 2022 were issued by that company, Metso. But the fact that at any given point Metso and Outotec are or are not related as parent and subsidiary is, in my submission, irrelevant. Furthermore, we would submit that it can't be right, assuming that there is a Henderson abuse point to be raised by Outotec in relation to the new proceedings. It can't, in our submission, be right that it's an answer to that to say, well, in the new proceedings, we're going to bring in a new party who could, of course, have been brought to the original proceedings. So, in our submission, the Metso PCGs is simply irrelevant. And furthermore, I'll develop this point a bit more in relation to Aldi, but clearly Outotec are prejudiced or harassed or oppressed by having a claim against them for £160 million, having already defended a claim in relation to the same project, in circumstances where, even if Metso, as the judge has held and as my lord has refused permission for, even if Metso are not.
Sorry, say that again.
Well,
having defended, you said they're harassing again because there's a new claim, having defended a claim on the same project, and then.
So that is prejudice or harassment or oppression of Outotec, even if it isn't those things in relation to Metso.
Why? Why? Why is it harassment? If just assume for a moment that a legitimate case management decision could have been to hive this off, which I think you would accept. It's possible. Why is it harassment to have, in this case, a completely new claim which has virtually no overlap on facts dealt with separately? I don't find the answer to that in your skeleton.
Well, no, I follow your lordship's asked me a similar question on a number of occasions. I'd like to come back to that under the Aldi guidelines, but the point I'm making at the moment is that the two defendants have to be considered separately. And let us assume, for present purposes, that there is oppression or harassment or whatever of Outotec. The fact that there isn't such oppression or harassment of Metso is irrelevant to the position of Outotec. It's irrelevant either way. If as my lord's putting, Outotec are not being harassed by these proceedings, then the Metso position is irrelevant. If they are being harassed by these proceedings, the Metso position is also relevant. Because on any view, Metso are not being twice vexed, they're only being once vexed.
Well, I think I understand that submission.
Yep.
I shall try not to ask similar questions too often, but I don't think you've answered my question. You made what I understood to be a submission. That Outotec are harassed or oppressed in having to meet a fraud claim, having defended a claim on the same project.
Yes.
I hope I've noted that accurately. My question is simply, why do you assert that they are harassed and oppressed? I need to understand a case on harassment and oppression. Whether it all ends up on the scrap heap doesn't matter, but at the moment, I'm afraid to say I think it is potentially material, and I don't think we find a case on harassment or oppression articulated beyond a mere assertion in your skeleton. So I'm trying to give you the opportunity to deal with it now.
Yeah, I follow that. Yes.
Yeah.
But
Your point is you will be addressing it, but later in your submission.
indeed, yes. Well,
Because this is an entirely distinct issue from the PCG point. At the moment, you're just addressing the PCG point,
yes.
and you're going to come on to my lord's question later. As I understand.
Okay.
Thank you very much.
but I won't forget it.
I probably will.
Yeah, I certainly won't forget it. So far as the PCG is concerned, there are potential arguments as to whether Mezzo are or not on the hook on the PCG, notwithstanding the fact that the judge declined to strike out that claim was upheld by Lord. And that in a sense is slightly secondary. But our overall point is two different claims, two different parties. My Lords, then coming to item 7, which is the other proceedings. Again, we would submit that those are simply irrelevant because the question is whether Outotec is being twice vexed in relation to Hull. The fact that there are, and it is, as I've shown you, a very substantial claim, the fact that there are other proceedings which raise to some extent similar issues, we would submit it is simply irrelevant. Indeed, the fact that there are other proceedings we would submit makes the prejudice in relation to Hull worse rather than better, because of having to fight similar issues on multiple fronts. My Lords, point 7 is not really one which can be massively expanded. So that's really what we say about that.
Worse, not better, because there's just more resources required to deal with different projects or claims under different projects.
So my Lords, coming into Aldi, and I will, in this section of my submission, seek to deal with the points my Lord Justice Stuart-Smith has put to me. So where do we get with the judgment? When we go back to that, that's in the core bundle. So the starting point is there is no doubt on the basis of the judge's findings that M&W did fail to comply with the ALDI guidelines. The judge, as I've already shown you, has then found at 130, page 73, that if they had acted with an appropriate expedition, the misrepresentation claim could, should, and probably would have been tried in the previous proceeding. We debated that point already. Now, how does he get there? If we go back in the judgment to para 118 on page 21, MW, para 118, MW could, had it decided it wanted to do so, have investigated and pleaded misrepresentation claim in reasonable detail by late 2019. So pausing there, that finding goes well beyond the conclusion that the issue could have been raised perhaps by a pre-action letter. They could have pleaded it out, as the judge finds. And the judge, in our submission, rightly rejects some of the excuses which are proffered by M&W for not doing so. For example, para 117 on page 70, if they had decided to commit resource to the misrepresentation claim, there is no good reason for concluding that it could not have investigated, asserted and pleaded the claim in reasonably short order. And then the judge at 115 rejects a point which I think surfaces again in Learned Friend's skeleton for this appeal, that they would have been fatally weakened in defending the claim, and he essentially makes the point, well, it's not uncommon for a main contractor to have to face a number of different directions. The judge also, going on to the should question,
And have I understood this correctly? In these paragraphs, there's a number of references to Mr. Velichko's witness statement.
Yeah.
And Mr. Velichko is the solicitor now, but wasn't the solicitor in the main proceeding.
that's right,
What I think of as the main action,
that's right.
because there's an entirely new legal team for MW in these proceedings as opposed to the main action.
That's exactly right.
Now, going back to the question of timing,
Yep.
the judge finds that it could have been pleaded by late 2019.
Yes.
Now, this is why I was questioning your statement that the relevant date was the date of the claim form, because it seemed to me to be implicit in your case that actually it had to be a later date, because late 2019 is after the date of the first claim form, which was July. But as I understand it, your case is late 2019 is plenty time enough, because that was round about the time of the first substantive CMC, which was October 2019. I mean, the judge is understandably not precise,
Yes.
but if we take it that it was around that time, you say that's good enough.
It is.
And you say it wouldn't have mattered if they couldn't have done it in July, if they could have done it in October.
That's exactly
And
right.
the obvious reason is because it's well ahead of trial.
Yes. Yeah. But that's right, but also because on the basis of the authorities we've looked at, MW could, and we would say should, have said to the court in, let us say, October, we've got this big claim, what should we do about it? And that, as the judge indicates, there was ample time to consider it in a case management conference. Of course, the judge might, at the third stage in the analysis, have said, I'm going to deal with this issue, not deal with that issue. That is, to a degree, speculation. So, my lords, having made those findings, why does the judge find against us? Because he concludes at paragraph 134, page 74, that although there's been, as he corrected, failures to comply with the ALDI guidelines, it is not the most egregious of non-compliances. Now, the first point to make about that is we submit that puts the test too high. It's apparent from the various Court of Appeal authorities we've looked at that the ALDI guidelines are mandatory, they've got to be complied with, and there's no indication in any of the cases that there has to be what the judge calls the most egregious of non-compliances. So in our submission, that was an error in the principle. The judge misdirected himself as to the test to be applied. But in any event, we submit for the following 6 reasons, which I'll just mention and then develop, that this was in fact a bad breach of ALDI. One, this was in fact a particularly egregious non-compliance. 2, the judge misdirected himself when he found to the contrary. 3, this is very much a Goldberg-Lindy type case of keeping a claim up a sleeve and not on the table. 4, the judge should have given more weight to his correct finding that the misrepresentation claim should have been brought. 5, the judge understated the prejudice to Outotec in having to counter allegations of misrepresentation made many years ago. And it's that 5th submission where I'll seek to deal with the issue of harassment or oppression. And finally, the judge did not give sufficient weight to the fact that this was a fraud claim. So, in relation to the first of those points, that this was a particularly egregious non-compliance with ALDI, it is, I think, now worth going to the M&W appeal skeleton. That's at Core Volume 2, Tab 11, page 505.
Give me, Mr. Williamson, what page are you on?
It's Core Volume 2, Tab 11, page 505.
Thank you.
The learned friend is making the point generally at 47 that there are lots of disputes between the parties, and he says those matters are relevant because 47.1 they justify or explain M&W's commercial decision not to bring its misrepresentation claim against Outotec in the whole proceedings. And that is more or less a word-for-word repeat of what they said in their skeleton argument below. And I've given you the reference, but just to give it again, it's supplemental bundle, tab 7, page 322, paper, or 324, electronic. The judge rightly rejected the various excuses which were offered by M&W as to why they had not raised the misrepresentation claim in 2019. And he concluded that it was more than probable, more than likely that if
Can you help me on this?
Yep.
As we've touched on already, there's two separate questions. One is whether it should have sued. The other is whether it should have notified the other party and the court of the existence of the potential claim, even if it didn't actually sue. Now, what excuse was put forward to justify non-notification? And where does the judge deal with that?
I think the best place to find that is para 121 on page 71. So they should either have pleaded it or notified the other parties in the court.
Well, exactly. But the question is, what was the excuse for non-notification?
Well, what?
That's simply recording the existence of the two alternatives.
Well, one submission that was offered, one gets to the second part of that paragraph, was that they had written a letter.
And he says they didn't.
So that doesn't notify this claim.
Yeah, and there's no respondent's notice on that.
Yeah.
Because I'll be candid with you. At the moment, it seems, and of course, this is not a point against you; it's a point in your favour. At the moment, I'm struggling to see any excuse that was given for non-notification. It was position taken seems to have been, and you say it still is. It was our commercial decision. We were entitled to decide.
So it's their case, yes.
But that seems to carry with it the fact that there's actually no excuse given for non-notification. And if I'm wrong, tell me.
Well, I mean, there are, in a sense, I don't want to be unfair to my learned friends, and there are matters, what I would describe as difficulties, which are raised for it and dealt with by the judge. For example, paras 115 and 116 on page 70. The judge was fairly scathing about those offerings, and in my submission, rightly so. And if I can make the following point, which I hope doesn't sound too much like a jury point, if it is right that a party can, competently advised party, can look at the ALDI guidelines, know it's got a very substantial claim, and then say, well, we're just taking a commercial decision to keep it quiet.
Yeah, you say the mandatory means mandatory.
But those guidelines really don't have any effect at all.
Yeah.
What should we be thinking by terms of analogy to the way that the court approaches breaches of mandatory provisions in the rules? Because these are judge-made. The ALDI guidelines are judge-made guidelines that have turned into rules. So if you have a mandatory, perfectly normal state of affairs, you have a breach of a mandatory provision of the rules, then you're into CPR 3.9 territory. Is there anything to be said by way of analogy for looking at the court's approach? Because one of my concerns about this case is that we're turning the ALDI guidelines into a super rule. And your submission is, if you breach the guidelines, your first thing is you are acting abusively. If not that, you're very, very nearly, or come down one stage further, you're at high risk of being found. Isn't there a risk of elevating the ALDI guidelines beyond what would be done with a breach of a mandatory provision of the rules?
Well, in fairness to my submission, the very high risk, I think, comes not from me, but from Lord Justice Briggs.
Yes. These are the stepping stones. We know how you put your case.
Yeah. But if one thinks about a Mitchell type, Denton-Mitchell type application of the court at the time that one hears quite frequently, that certainly hasn't, so far as I'm aware, hasn't found its way into any of this line of jurisprudence. That's the first thing, even by analogy. And secondly, just thinking that through, then the court would need to consider how serious is the breach, what is the explanation for the breach,
and the consequences.
And the consequences, yes. But it's a bit difficult to reconcile bringing in a Mitchell approach to the approach indicated, for example, in Gladwin.
I agree. And I find that I don't know what the answer is, but I find it troublesome and not entirely straightforward that we've got this line of super rule based on an obiter comment of Lord Justice Thomas, as he once was, which has then been reinforced and elevated, subject only to what Lady Justice Arden says in a case whose name I cannot now pronounce, even if I can remember it correctly.
But with respect, Lord, isn't there, if we start bringing in Mitchell, isn't there a 3.9? Isn't there a risk of confusion? Because the analysis one's looking at here is could the claim have been brought? So if the party respondent to the application says, well, I didn't have the documents, I didn't have the information, so on and so forth, which is the usual sort of territory one gets into on these applications, then the court will say, fine, you go ahead with your new proceedings with the court's blessing, as well. And then you have the should question. And it's in my submission in danger of confusion if one's going to start bringing in the separate.
And then, depending on how you analyse it, and I'm not going to repeat a question which I've almost asked about 3 times, I think, before. If you get to the stage of saying, yes, it's an abuse, what do you do about it? And what brings it? I mean, that may be the answer, that this, because it's not a CPR provision, the judges have developed it with these incremental, what I'm going to call incremental stages. And that's where the analogy comes in. You can see similar considerations as would arise under CPR 3.9.
Yes.
Thinking aloud, one way of looking at it might be to say, well, first of all, you ask, could the claim have been brought in the earlier proceedings? If yes, should it have been brought in the earlier proceedings? If yes, prima facie, that's an abuse and will lead to striking out. But a possible answer is to say, if you are the party bringing the second claim, but it's not an abuse, even though it could and should, because I complied with the oldie guidelines. I didn't sue, but I notified the other party and I notified the court. Is that a way of looking at it?
I'd be content with that way of looking at it, yes.
If I can triangulate for a moment, I would, just because this is a new hat,
yes.
I would go with my Lord Justice Arnold on his formulation, save that I'm still looking at the existence of a flag which has the words oppression or harassment or whatever, and quite how one works that in. Obviously, we're going to need to go away and think about it. But I think that would be my footnote to my Lord's formulation.
Yes.
At the moment.
Well, I am, as long as promised, I am going to come back to harassment.
I'm trying not to repeat it.
No. I am coming back to it. So the second point I was going to make, second submission I was going to make under this heading was that the judge misdirected himself in concluding that this was not the most egregious of non-compliances. And the reasons that he gave are paragraph 134 on page 74. The first reason, he says, is it can't be said that Outotec is now faced with an entirely new claim, which is very closely connected with the previous proceedings. In our submission, although it raises additional factual issues as to the alleged representations, etc., it is closely connected to the original proceedings because, according to MW, but for the fraud, they would never have entered into this subcontract at all. And so they say that it gives them, so to speak, a get-out-of-jail-free card in relation to the original proceedings. And it therefore, as we saw in relation to the quantum claimed, it requires the court to go back to essentially everything which was an issue in the original proceedings. It makes the original proceedings completely futile, if right, and means that the court's time dealing with those original proceedings was entirely wasted. So in our submission, that is not with respect a good point. Secondly,
Just
yeah.
I think that's true. I mean, one of the features of the claim, the new claim, is that there's a claim for, as I understand it, all the costs incurred in the previous action, which includes the fact that MW had to pay Outotec indemnity costs because of a Part 36 offer they didn't beat.
Yeah.
So, as an example of this submission, you say, well, therefore that would have to be looked at again as part of the damages claim, because you would say, well, there's a intervening cause, the failure to beat the Part 36 offer, so that you would be entitled to rely on that, and they wouldn't be able to reopen up that part of the claim.
Yes.
So So your short point is that there is overlap.
Indeed. Yeah.
Although there's obviously not overlap with the misrepresentation claims themselves.
No,
You don't say that what was said or emailed or whatever between 2011 and 2015 was the subject matter of the main action.
No, but as I showed your lordships a little while ago, they do rely on the defects, which they say is part of the proof of the falsity of the representations.
Yes,
That takes us back into all of that.
I get that, but so that's why it's not a case of no overlap at all on the allegations part because of the link to the defect. But in general terms, I think you would accept that the misrepresentations themselves, dating as they do from 2011 to 2015 before the subcontract, were not themselves in issue in the main action.
That's right.
So on the defects question, what's the position there? Is the findings in the first action, are those findings as to the existence or otherwise the defects raised judicata?
I think they'd have to be, but it may be there. I haven't really thought about that, to be honest. It may be there is some route which would allow.
One way to test the question is this: in the new claim, is MW relying on defects which were found not established in the first claim? And has it pleaded reliance on the findings in the first claim?
It certainly hasn't done the latter. No.
Well, that's astonishing. So they're not asserting res judicata.
No.
So that if they don't even assert it, it necessarily follows that the defects will have to be tried all over again.
Well, it would be open, I suppose, to Outotec to assert it.
Sorry, say again, I missed that.
It'd be open to Outotec to
You
assert
told us you filed a defence. Have you pleaded to raise judicata?
But, my lord, can we just... Mr. Berry is the master of the pleadings, so I'll just leave that point for him to check. My lord, just going back to paragraph 134, the second point the judge makes is he said it can't be said with complete confidence that the misrepresentation claim would have been litigated as part of the previous proceedings, or therefore that Outotec is now beyond doubt faced with a very expensive and very disruptive second set of proceedings which should and would have been avoided had been applied. Well, the first point to be made is that the judge is putting the test too high. There doesn't have to be complete confidence or beyond doubt. But in any event, the question is not whether the misrepresentation issues would necessarily have been tried in the original proceedings. The question is whether they, as previously submitted, they should have been at least notified within the scope of the original proceedings, which they were not. But in any event, at that point, with respect, the learned judge seems to have slightly forgotten the fact that earlier in the judgment he held that it was perfectly possible that the case managing judge would have directed that the misrepresentation...
He went further, he said probable.
Yeah. And then the third reason...
Oh, just on that one, sorry to pause you again. What the judge was obviously concerned about, both in this paragraph on this topic and some of the earlier paragraphs, was the point that it was possible that the misrepresentation claims, if they'd been notified and then the judge had said, well, plead them out, that they might still have been hived off and dealt with separately and later, and therefore, although the judge doesn't spell this out, it appears that one of his concerns was that is not very different to what's happening now.
Well, of course, it is different because in that hypothetical scenario, you've got the court being told in 2019, we've got all these claims, including a misrepresentation claim. The court, in its case managing function, wanting to see that all of those claims are dealt with as expeditiously and economically as possible, and the court considering how best some issues could relate to other issues.
But the key difference is the one we've just discussed, is res judicata. If you have two trials within one set of proceedings, the findings in the first trial are res judicata for the second trial. So if you have defects tried in the first trial, and there's findings as to the existence or otherwise of those defects, then that's the basis upon which you have the second trial. You don't try defects all over again in the second trial if it's in one set of proceedings. By contrast, if you've got distinct proceedings and there's not even any plea of res judicata, then you try them all over again.
Yes, essentially. But in terms, I think that's certainly a correct rule. But in terms of my Lord Justice Coulson's point, what wouldn't have happened if there had been an ALDI notification in 2019 is that the case managing judge would then have said, do you know what would be a good way of dealing with this? And that would be to have a trial in 2026. And the judge, the case managing judge, a point I'll come to a bit more detail in a moment, would have been conscious of the fact, in my submission, that in relation to misrepresentation, you're dealing with very serious allegations of dishonesty in relation to statements allegedly made many years ago by named individuals. In those circumstances, we would submit it would be highly unlikely that a case managing judge would say that can be put off into the far distant future.
I understand that point, but can I explore the logic of a submission you made a moment ago about the way the current claim is pleaded when you got to loss and damage? Because I think the logic of your submission is that if the audit guidelines have been complied with, and let us suppose that the case managing judge had concluded that having one trial was too burdensome for all concerned, and therefore decided, okay, I'm going to have two trials. I think the logic of your argument earlier is that the correct case management decision would have been to try misrepresentation first. Because if established, then the contracts would have all been set aside and all the other issues would have gone out the window. Is that right?
I think that is right, because the contractual any contractual basis of a claim against Outotec would, as you say, would have fallen away. But also, and this is why it's so important in relation to cards up sleeve and on the table, is because this fraud claim, if it's right, is a complete answer to everything so far as M&W is concerned. It blows everything out of the water. My Lord, the third submission, the third point I was making, which I think we've probably already covered, is that what Goldberg-Lindy establishes is that where there's a breach of ALDI, you're at very high risk of being struck out, and we would submit in circumstances where a party has reached a commercial decision not to pursue a claim, notwithstanding the guidelines, not to notify the court, then it is at particularly high risk of striking out. Fourthly, the judge ought to have afforded more weight to his finding that the misrepresentation claim, quotes, should have formed part of the original proceedings. And I've made the point that that's necessarily abusive. Now, my Lord, coming at last to my Lord Justice Stuart-Smith's run of questions on harassment, etc., we submit that the judge took, if I may say so, a somewhat relaxed approach to the effect that all of this is going to have on Outotec. And my starting point for that is his paragraph 135 on page 74, where he says that allowing the claim to proceed will result in Outotec having to defend statements made up to 14 years ago, and some people may have left employment. No specific details of specific prejudice are provided, and he is unimpressed by a witness statement in that regard.
Can I pursue the question I asked earlier?
Yeah.
Because what we've now established is that it appears that defects are going to be tried all over again. Was that brought to the judge's attention?
I think we did debate that point in front of the judge, yes.
Right. But he doesn't mention it. Seemed to have completely ignored that prejudice.
Well, I'll Well, in fairness to the judge, I'm reminded, if you could go to page 76, arrow 141.
Well, at the moment I'm struggling to understand this. I mean, maybe you can explain it, but it doesn't seem to address the point that the defects are being relied upon to establish, as part of the material, I appreciate not the only material, to establish the misrepresentation.
That is where he deals with the point.
All right, well, can I ask my question in a different way? Do you accept what he says in 141, or do you say he's wrong, and if so, why?
Well, to be fair to the judge, we haven't addressed that particular paragraph in our notice of appeal or our skeleton argument. I think the way I would put it is that we are dealing with the same plant and equipment in the new proceedings and the old proceedings. There is overlap to that extent. It may well be right. It's not a point that we've researched for this appeal in any detail. It may well be right that there are detailed distinctions between what's been litigated before and what's now sought to be litigated.
Well, I'm bound to say I find all of this very puzzling, because in 142, he says it's unnecessary to lengthen the judgment by referring to the difference between issue estoppel and hence abuse. But of course, issue estoppel only arises if it's pleaded. You have to plead issue estoppel. And at the moment, unless I'm corrected, my understanding from what you've told me is nobody's pleaded issue estoppel. So unless and until it's pleaded, you have to do it all over again.
Well, I'll come back to the pleading point if I may at the end. But could I? I'm not trying to duck my Lord's question, but having ducked my Lord Justice Stuart-Smith's questions on a number of occasions, can I come back to that for the moment? So, the learned judge was not impressed by the prejudice of which Outotec complained. Can we just see what that actually is? So, if we could go in the court to volume 1, tab 7, schedule 1, which I think the Lordships have not yet had the delight of looking at, which begins at page 145.
Sorry, this is the supplemental bundle.
No, this is the main
Core bundle.
Core bundle 1.
Tab 7.
Tab 7.
Yeah.
Page 145.
The schedule.
Schedule.
Yeah.
So this is where the details are set out of the alleged misrepresentations.
Yeah.
And just taking a few, if you could go to 156. Item 17. In June 2011, Mr. Starkey, who's an Outotec man, is said to have attended M&W's offices in Chippenham. There were other people there, and he's said to have made representations as to the experience which Outotec had, which is now relied upon. And then page 165. Item 25, in September 2012, Mr. Starkey gave a presentation.
Sorry, I'm behind you. Page
165, item 25.
Thank you so much.
Mr. Starkey is said to have made a presentation, which was also a misrepresentation as to the experience which Outotec had. So I've skipped over, sorry. And then if we could go back to page 161. Item 22, September 2012, there were representations by Outotec in a conference call, Mr. Starkey, again Mr. Murphy, again as to the experience which Outotec had with various plants, and then more recent 235. What's said to be a gasification seminar, October 2015, delivered by Mr. Starkey and others. And again, representations are said to have been made. So, my lords, the point we make is that in terms of prejudice or harassment or oppression is really twofold. First of all, we are dealing with a large number of representations alleged to have been made, some orally, a long time ago, and the truth or otherwise of those statements will be tried out in 2026, 10 to 15 years after those statements were made. And although the judge was dismissive of the point, in our submission it is self-evident that is going to make Outotec's life in dealing with this claim extremely difficult. And picking up my Lord Justice Arnold's point, and to repeat a point I've already made, we would submit that there is no way that if Aldi had been abiding by in 2019, the court would have said in relation to these claims, misrepresentation, that they could wait for another 7 years before they were tried.
But of course you wouldn't then have assumed 15 months for a judgment and things that have happened, so you'd have to look at it as the landscape was in 2000. 19.
I accept that, but the landscape would have included this in my submission, that the case managing judge would have said to himself or herself and to the parties, we've got very wide-ranging allegations of misrepresentation. There are named individuals who are said to have acted dishonestly, and a huge amount of money turns on it, which, as my lord put to me, I think rightly, really overturns the apple cart, as it were, of the whole of the other proceedings. And in those circumstances, we would submit that the case managing judge would have been anxious to ensure that these allegations were tried as swiftly as reasonably possible. That is one point we would submit on prejudice, harassment, oppression. Another point is this, which is that Outotec, of course, it is a commercial company, and it was entitled in our submission to take the view that the original proceedings were going to be the full menu, as it were, arising out of Hull, so that
full extent of potential liability.
I didn't hear that.
Full extent of their potential liability.
Exactly, yes. So,
so you contrast with that. You contrast that with WSP and Aspen Wall. In that case, Lord Justice Thomas found that they were aware that it wouldn't necessarily be the full liability.
Exactly.
Because they've been notified.
Because they've been notified. But again, in terms of my lord's Mitchell-Denton type point, I appreciate that's only a potential analogy. Outotec were in my submission reasonably entitled to think themselves in 2019 as these big claims came down the road. Well, that's what we've got to provide for. Not
because by that time the whole car crash had happened.
Absolutely.
Everything had been terminated.
Yes.
And everybody knew they had a walking disaster on their hands.
Exactly. And that it was going to cost someone a lot of money. So, my lords, we do submit that we're prejudiced / harassed / oppressed by these further proceedings for those two main reasons. And the final point we would make is that although the judge clearly was aware that this was a fraud claim and a very substantial fraud, we submit he didn't give sufficient weight.
Before you go on to the fraud aspect, while we're still on the harassment and oppression aspect, I've belatedly realised that the relevant paragraphs of the judgment dealing with defects are in fact 143 and 144. Because it's at 143 that he sets out the plea in the particulars of claim paragraph 58, to which you drew our attention, which is the reliance upon the defects to demonstrating the misrepresentations made. And then he says in the middle of paragraph 144, given I've decided the contractual claim cannot succeed, it would be wholly inappropriate for any defects which are not properly capable of being relied upon to support the misrepresentation claim to be left in through inadvertence or otherwise. I would therefore expect MW to take a careful review of this part of the pleaded case. Which seems to be the answer to oppression is that the party bringing the claim should proactively prune its own case. Or is that putting it too strong?
Well, I think what the judge was seeking to ensure was that they couldn't keep in anything which was purely the contractual claim, but they could keep in aspects of the defects which were relevant to their overarching point.
69, he says specifically, just picking up on my Lord's point, at the top of the next page, they don't have to plead to 69 to 76, I think it is, and that's the defects.
That's right. So that we haven't yet pleaded to. So Senator O'Reilly, what is outside your bundles? But what has happened since then is that M&W have served an amended,
A proposed amended,
particular
if they get back in, or if they stay in.
Exactly. Yes. And we are in the process of drafting a defence to that at the moment.
So are 69 to 76 still relied on, or have they been deleted, or what?
They're relied on in a what my lord called a pruned form.
Right.
Relied on in a
Pruned.
pruned.
The pruning shares have come out.
You have accepted that. You have accepted that it's been consented.
Yes, I was just going to. This is more or less my final submission. I was going to say something about fraud, which is that we would submit that considerable weight should be attached in the scales to the fact that this is a fraud claim which is very substantial, both in the sense of the breadth that one sees in schedule of representations and as to the amount of money which is claimed as a consequence. And we would submit that if we look at all of the cases in the round, that this was a paradigm case for the cards being put on the table and not kept up the sleeve. And just pursuing the cards analogy one moment longer, as we sat masked in June and July 2021, trying out the existing claim, M&W, by their own account, knew that all of this might be a complete waste of time because they had a card which was face down point fraud, which answered everything, and yet they didn't tell the judge that, and they didn't tell us that. And we would submit that if that isn't a case which breaches ALDI and requires a strikeout, it's hard to imagine a case which does. So, my lords, those are my submissions. In relation to my lord's question about the pleading of the defects, I haven't answered that adequately yet, and we will chat that over the lunch together. And if I may interpose at 2 o'clock with anything that needs to be said on that. My Lord, so far as my Lord Justice Stuart-Smith's questions, I hope that I have now sought the latest to engage.
Maybe.
So those are my submissions.
If I think of something, you'll get a chance.
Yes, thank you very much, Mr. Williamson. Thank you. Mr. Howe.
Good afternoon, my lords. My lords, coincidentally, I am also going to put my submissions under 8 parts as well.
Are they different or the same?
They're going to be quite different. Part 1, I will start with my central submissions on both grounds of appeal in a very summary form. In Part 2, I will identify what I say are the distinctive and important features of this case that are novel and affect the application of the principles to the facts. In Part 3, I will emphasise a number of legal propositions from among the wider landscape, which I submit, particularly having heard the oral submissions this morning, are prominent and important. Then I will deal in the next 3 sections with the broad merits-based review under 3 headings. So Part 4 will be submissions that focus on MW's conduct and the closely related question of culpability. Part 5 will focus on the ALDI guidelines including the case management element of those rules. And that will take into account questions of the wider effect of the second action on the court and on other court users. In part 6, I will make submissions that focus on the effect of the second action on Outotec, where the question of oppression or harassment will be in the foreground. In part 7, I will then briefly restate my central points with the benefit of any refinement that comes out of the discussion with the bench. And in part 8, I'll address what may be a non-issue, but may not be, which is the question of the position of mezzo, not as a facet of the broad merits-based inquiry, but the submission still trailed orally that there is some reason to think that that claim might yet fall away, and I'll deal with that towards the end, really as its own discrete topic. So, my lords, the course of part 1, the course submissions on the 2 grounds. Ground 4 is what I will call the irrelevant factors ground, where the submission is that the judge's reliance on the presence of a parent company guarantee claim and the other proceedings were irrelevant, or as I think it was put in a slightly modified form orally, he gave too much weight to those factors, which is quite a different submission. My submission is those 2 factors were relevant. The judge was right to take them into account. And my lords, I will develop and go a step further and say, in fact, he was right to regard them as particularly important features in this case. Ground 5 is the wider ground, where Outotec says that the judge was simply wrong in his broad merits-based assessment. My submission will be that he was not wrong, and I will positively assert that he got the decision right. And my lord, still under part 1, just to expand a little on why we say he was right. I've set out, or we have set out in our skeleton, the familiar central duality where one asks, could the second claim have been brought, and should the second claim have been brought? And it's clear on the law that that is assessed by reference to this broad merits-based inquiry. The authorities are clear that the central question remains simply whether in all the circumstances the court's procedures are being abused. But my lords, breaking that down a little further, I submit that within that broad inquiry there are recurrent points of focus in the cases, of which I identify 3. First is an assessment of the claimant's conduct, and that includes the question of compliance with the ALDI guidelines, and where there is a breach of those guidelines, the seriousness of that breach. I suggest that the cases divide into situations where, on the one hand, there has been culpability of some kind, or on the other, cases where the fairer characterization of the claimant's conduct is that they have sought to steer a reasonable course through often difficult and complex commercial litigation. Now, I will submit that this is a case where MW did its best to steer a difficult course through what was undoubtedly complex commercial litigation. I will lay some emphasis on the fact that significantly and novelly, it steered that course as a defendant in the earlier action, a feature that distinguishes this case from all of the authorities in the bundle, where the conduct of the party under scrutiny has been the conventional claimant in both the first and the second action. I will go on to develop why I say that is a significant feature in the assessment of the claimant's conduct. Second, in terms of these focal points of the inquiry, is an assessment of the impact of the second set of proceedings on the resources of the court and the legitimate need of other court users, and of course the broader public interest inefficient litigation. Again, my lords, I will say that in the cases one sees broadly a divide between situations where, on the one hand, a party is simply misusing court time and resources, either through underhanded or at the very least inefficient behaviour. And on the other side of the line are cases where, when carefully analysed, the impact on the court, its resources and on other users is in fact limited, or certainly within reasonable bounds. And I will submit that we are on the right side of the line on that inquiry too. We will say that the earlier proceedings, which I'll call the EWHL proceedings, were a sprawling and resource-intensive piece of litigation as they already were, that folding the misrepresentation claims into that action would have greatly increased the already significant burden on the judge. It is, I submit, very clear that doing so would have required additional court time and resource. And I do say that on the facts of the case as they have panned out, the position reached now is that no greater or additional court time and resources will be taken up in future in dealing with those issues than would have been needed to deal with them in the original claim, or at least at some earlier stage. And the high point of my submission as to these case management aspects of the inquiry is that the judge's decision below on abuse and his subsequent case management order, which ordered by consent that the residual claims in the present proceedings will be tried alongside the Surrey claim. The ultimate result of that is that the misrepresentation claims will now be determined in a quite desirable way, because the claims of misrepresentation, which substantially overlap across the projects, will be determined in relation to both the Hull and Surrey projects in one trial, with one judge looking at the evidence and making findings that will affect both of those actions. Now, as it happens, that trial will take place in 2026 after an ICC arbitration taking place in Edinburgh this summer, which is about the Levenseat project, the Scottish project, where again, the issues of misrepresentation are going to be arbitrated. I submit that the end position reached, far from being abusive, has some positives to it. The third focal inquiry to which I referred...
Can you do... I
Yes.
know it's 1 minute to 1. What is the relevance of the Edinburgh arbitration? Let's assume all goes well in one way or another. It concludes with an arbitral award. So what? What's is it the hope that parties might take one look at that and decide, well, this is not worth relitigating and reach accommodation on that basis, or what?
Well, look, we always hope that, but there is a harder-edged point, which is about evidence.
Which is about what?
Evidence.
Yes.
The judge below, when dealing with case management in this case, extended the invitation, and indeed I would say encouragement to the parties that they might well wish to rely on the witness statements produced in the ICC arbitration for the purposes of determining the issues in these proceedings as well. Now, whether that in due course happens is a matter for the parties, but you can see that to the extent that these issues are going to be dealt with in the Levenseat arbitration, there may yet be benefits in terms of cost, in terms of time, and in terms of repeating the same work that could be saved if then any of that material could be redeployed in these proceedings. Likewise, expert evidence to the extent that it addresses the same issues. But to be clear to my lords, there is no agreement, as far as I'm aware, that that is going to happen.
No.
So
But
I can't.
there is the potential.
There is the potential, and it has been encouraged by Judge Davies as something for the parties to think about. But, my lord, that is a point at the periphery of my submissions about the case management points. And perhaps, given the time, if I just try to finish the third focal area of the assessment.
Yeah.
That is the effect of the second set of proceedings on the defendant here, Outotec. And again, I will say that the cases divide into situations where, on the one hand, the pursuit of the second action heavily overlaps with the first, and thereby subjects the defendant to oppression or harassment, and we'll look at where those words come from in the authorities. And that oppression and harassment takes the form of being vexed twice, as the expression goes. But on the other side of the line are cases where, in fact, on closer analysis, the second action is not of that character or of that effect. And my submission is the judge correctly found that this was a case on the right side of the line from MW's point of view on this inquiry too. It appears, following my learned friend's helpful submissions, to be certainly common ground to a large extent that the misrepresentation claims are a fundamentally different type of claim that are focused on a different period. And I think I will look over lunch as to whether I can trim some of the things I was going to say about that in light of the apparent agreement on that. In contrast, I will be looking closely over the lunch break at the question of defects, although I think I have some points already on that. We do say, in addition, my lords, that it is a singular feature of the present dispute that these parties are engaged in a series of claims, in a series of disputes about different projects. And I do say that in light of that reality, further trials between them were always likely. The original Hull action only came about first because, as my Lord Coulson has observed, the employer terminated and then wanted to find out, as one would, whether they'd done the right thing. It is a very important feature of this case that across the three projects, the technology used was the same to all material purposes. It is also a highly relevant factor that MW's misrepresentation case is pleaded on the particular and express basis that misleading statements made in relation to each and any of the three projects were relevant to and induced MW to enter into each of the three subcontracts. So the misrepresentation inquiry will be looking at the evidence in relation to all three of the projects to that extent. And in my submission, the combination of these factors means that, unusually in this case, Outotec always faced the prospect of being vexed with defending the misrepresentation issues again in another trial or even trials relating to Surrey and leave and seat, even if those issues had been determined in some way in relation to Hull in the earlier action. Another singular feature of these...
You're now trespassing
into lunch.
You were summarising your submissions, but there's now too many of them. So we'll come back at 2:05.
Thank you.
Court rise, if able.
Thank you.
First time.